Update in the Koberger case, we do have a document dump, and this is regarding the motions that they went over in the hearing last week. Some were pending, some he already ruled on, but I'll go over them in order. The first one is regarding inflammatory evidence, and this motion has been denied. The second is using the term murder, and of course, if you see here, the state acknowledged it would be improper to refer to the defendant as a murderer, other than going over the allegations of the charges. Therefore, a motion is denied as unnecessary. Then we have the motion regarding the use or terms of psychopath and sociopath, and that motion has been granted, so they can't use those words. The next motion is improper death penalty comments. Again, an example would be the state is attempting to kill Bryan Kohberger. That motion has been denied, and he basically said that he expects both sides to act professionally. The next one is the motion of unnoticed 404B evidence, and this is regarding that final paper and the Amazon history and those things being presented as bad acts. The defense wants these things excluded. Motion denied. Then we have the motion regarding improper expert testimony and excluding IGG evidence. This motion has been granted, and the court advises both parties to arrive to a mutual agreement about the tip. We then have the motion of conditions as aggravators, and this is where the defense moves to prevent the state from using the autism spectrum disorder as aggravators, and this motion has been granted. The next motion is regarding alternative perpetrator evidence, and this is the state's motion where they seek order prohibiting the defense from offering alternative perpetrator evidence without showing such evidence is relevant or admissible. And the court says, to avoid undue delay at trial, defendants must present proof no later than May 14th, so the matter can be addressed at a pretrial conference. The next motion is statistical analysis, and this is the defendant's motion to exclude any misleading comments about meaning of likelihood ratio for DNA purposes. The court will not dictate how the question is to be asked at trial. If defendant believes there is a similar misrepresentation as to likelihood ratio at trial, he can object at that time. Next motion is regarding inconclusive data, and this is where the defense moves to limit expert testimony about the Idaho State Police Forensic Lab statistic analysis of swabs taken from fingernail clippings of Madison Mogen. And this motion was denied as moot. The next motion was the defendant's motion to exclude Amazon click activity evidence at trial, and that motion has been denied. Next motion is the state's motion regarding the AT&T timing advance reports, and this motion has been granted. Next motion is the state's self-authentication of records and reliance. And that one says that the court's motion on this ruling is reserved. The next motion was the state's motion of demonstrative evidence, and that would be the 3D model of the home, and that has been granted. Next motion is the state's motion regarding alibi, and this motion has been denied, subject to being re-raised if defendant discloses new alibi evidence. The next motion was regarding the state's motion of the prior traffic stop, and that motion has been granted with noted redactions. So the judge is going to review it, and if he thinks something should be redacted, that's what will happen. Then we have the state's motion regarding the neuro and psych evidence. ASD explainable demeanor is only admissible if defendant testifies. You then have the court reserves ruling of admissibility of OCD evidence. And this state's motion was also granted. We then have the defense's motion regarding the bushy eyebrows, and they're arguing, saying that basically Dylan shouldn't be able to identify him with bushy eyebrows. This motion is denied.